All right, Sergeant, can you swear in Mr. Williams?
Raise your right hand. You swear firm testimony you give the truth, whole truth, nothing but the truth.
Jeffrey Williams, Jeffrey Williams.
Good afternoon, Mr. Williams.
Good afternoon.
Are you the same Jeffrey
Oh my
Williams
God.
indicted in case number? Your Honor,
Yes, ma'am.
actually, have we all signed the indictment, or are we going to do that afterwards? Because I don't have a copy of it.
I don't know the answer to that.
I don't believe that we have.
Not signed the indictment.
Okay, probably be a good idea to do that.
First time Love is speaking this week.
Yes.
Where's the one we were using yesterday? We'll do that in just a minute. You can go ahead with the colloquy.
And Your Honor, we don't have the waiver form as well. I believe that the court had one.
That right here.
I've got blanks. Y'all filled one out, right?
We have.
Okay.
Thank you. Mr. Williams, are you the same Jeffrey Williams indicted in case number 22SC 183572?
Yes.
Okay. And are you also known as Young Thug?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you?
33.
And how far have you gone in school?
9.
Say that one more time.
9.
Okay. Are you able to read, write, and understand the English language?
Yes.
All right. Do you understand that you are charged with the following offenses? Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, participation in criminal street gang activity, the leadership charge, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, 3 counts, possession of a firearm during the commission of a felony, and possession of a machine gun. Do you understand that?
Yes.
All right. And do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you will continue to receive a jury trial?
Yes.
All right. And have you received this waiver of rights form that I hold in my hand from your attorney and reviewed it with your attorney?
Yes.
All right. And is this your signature on the bottom of this form?
Yes.
Have you had enough time to speak with your attorneys, Mr. Steele and Mr. Adams, about all of the facts and circumstances known to you regarding the charges in indictment 22SC 183572, including any potential defenses?
Yes.
Do you need additional time to discuss this case with your attorneys?
No.
Are you satisfied with their services?
Yes.
Mr. Steele and Mr. Adams, do you on behalf of Mr. Williams waive a formal reading of this indictment?
Yes, Your Honor. We do.
And do you, Mr. Williams, waive any and all defects in this indictment, including any with respect to your name?
Yes.
Have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorneys know of any outstanding warrants related to these charges?
Any what?
Outstanding warrants related to any of the charges in the indictment?
No,
No.
I don't believe so either, Your Honor.
Okay. And I'm unaware of any as well, Your Honor.
I am as well.
Thank you. Have your attorneys advised you of the minimum and maximum sentence for each of the crimes that you are charged with?
Yes.
And each of the charges that you are pleading guilty to?
Yes.
All right. Your Honor, with respect to the charges that Mr. Williams faces,
Do we have a glitch?
count 1, carries a minimum charge of 5 years and a maximum charge of 20 years in prison or up to a $25,000 fine or both.
Isn't it a $15,000 fine? Because wasn't it the version of the statute in effect at the time? Or was that the same for RICO? Was RICO 25?
Yes,
That-
RICO was
okay.
25.
All right, thank you.
You're welcome. Count 56 carries a minimum sentence of 5 years in prison, a maximum of 20 years in prison, consecutive to any other sentence, with a fine of $10,000 to $15,000 or both. Count 57 carries a minimum sentence of 5 years in prison and a maximum sentence of 20 years in prison. Count 58 carries a minimum sentence of 1 and a maximum sentence of 10 years in prison. Count 59 carries a sentence range of 5 to 30 years in prison. Count 60 carries a sentence.
Hang on, slow down just a second. All right, and that's for the amount of that drug that was found on 59, 5 to 30?
That's as a result of the charge itself, I believe, with intent to distribute.
I think that 59, Your Honor, is
Uh-huh.
simple possession of cocaine. I have to look at the indictment to be
I think
sure.
that's 60.
Okay.
The max on all these counts already is 100 years, guys. He's not going to get the max, but oh my God, he's pleading it open in front of this judge.
59 is codeine and
Yes,
60 is cocaine.
yes.
So,
Your Honor, it is with the intent to distribute. So my reading of the statute is that it carries the range of 5 to 30.
okay.
And Your Honor, also, as I have the indictment in my hand from Ms. Roster, may I pass it to counsel for Mr. Williams?
Yes.
Thank you.
Thank you.
Count 56, the max is 20. Count 57, the max is 20. Count 58, the max is 10. Count 59, the max is 30 years in prison.
Your Honor, with the court's permission, I'll permit time
Go
for
ahead.
them to. Okay. Count 60 carries a range of 1 to 5 years in prison. Count 61 carries a mandatory 5 years consecutive to the underlying felony. Count 62 carries a sentence of 10 years consecutive
Oh my God.
for a total maximum exposure of 120 years in prison.
Oh my God.
That's awful.
Were you aware of that, Mr. Williams?
Yes.
Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections or the Board of Pardons and Paroles, and that if you are sentenced to confinement in the Georgia Department of Corrections, no one can guarantee parole?
You can say yes.
Well,
She asked you, do you say that? you
Oh,
can
yes,
guarantee
ma'am.
Parole.
Your Honor, may I allow Mr. Williams time to finish signing the indictment?
Okay.
Just as a salute to the members, I'm gonna make this one, I'm gonna close it to the members, man, just to give y'all a special shout out. This is the culmination of the case. It's not gonna end the case because there are two more defendants. Yak is not pleading guilty. Shannon Stillwell is not pleading guilty. But this, according to Attorney Love, is the pack leader. He is the leading wolf of the pack. So shout out to all the members. Thank you for your support.
Your Honor, with permission, may I approach with a member of Mr. Williams' team?
You may.
Thank you.
Man, Fit Lawyer ATL, talk to us. What's going through your mind? What is going through your mind as a damn near 2 decades of criminal law experience? What do you think?
What in the hell is
Right,
going on?
what's going on?
So many charges. I thought we just had 2. Hell no.
Did y'all see my reaction when I heard non-negotiated? I couldn't believe it.
We haven't heard it though. So the state is still going to give us what they were offering. And so they're still going to put it on the record. But so we haven't finished hearing everything because I need to hear her say we are agreeing to dismiss blah, blah, blah. Because if the judge has to sentence him on all of these charges,
he's going to jail for life. He's going to jail for life.
That's not going to happen. That's not going to happen.
Listen.
Be up here doing this.
How old is he? How old is he? A 30-year sentence is that dude's life, if we're honest. I want to hear the cap. What is the cap? If they've agreed to a max.
Right. Okay.
Like that, right? If they've agreed to a max, what's the cap?
Right.
Y'all are saying that he's 33, man. Even a 20-year sentence, that's his life. His rap career is over. No record
Mr.
deals.
Williams, do you understand that this is a non-negotiated plea of guilty, and that since your guilty plea is a blind plea or a non-negotiated plea, the state is making a recommendation of sentencing to the court,
Oh, here we go.
notwithstanding the fact that this is a blind plea. You understand that, Mr. Williams? Okay. And Mr. Williams, were you aware of the state's previous offer that was turned down prior to your making this non-negotiated plea?
Yes.
All right. And Your Honor, at this time, the state is making a recommendation of 45 years with 25 to serve in custody, followed by 20 on probation,
Oh my God.
subject to the special requirements of 1615 the gang statute.
45 do 25.
All right, and do you want to break down for me what your recommended sentence on each count is?
Yes, Your Honor. The state is recommending on count 1, 5 years to serve. Count 56, 20 years to serve consecutively to count 1. Count 57, 5 years of probation to serve consecutively to count 56. Count 58, 10 years of probation to serve concurrently with count 57. Count 59, 5 years of probation to serve concurrently with count 57 and 58.
Oh, no.
Count 60, 5 years of probation concurrent with count 57, 58, and 59. Count 61, 5 years of probation consecutive to count 57. And count 62, 10 years of probation consecutive to count 61.
All right, thank you.
Mr. Williams, did you discuss the state's previous offer with your attorneys?
Yes.
Okay.
All right, and so we're all clear that we're talking about the same thing. Can you put what the state's previous offer was on the record for me, please?
I can, Your Honor.
Thank you.
The state's previous offer was a total of 43 years with 20 years, 5 years to serve on count 56, commuted to time served, followed by 15 years on probation. On count 58, the sentence was 10 years to serve in the Georgia Department of Corrections, consecutive to count 56. Count 59 was 3 years to serve in the Georgia Department of Corrections, consecutive to counts 56 and 58. Count 60 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, and 59. Count 61 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, 59, and 60.
No.
Was that the entirety of what the sentence was?
No, Your Honor.
I mean, I know there were special conditions, so y'all were
There
going
are.
to null pros,
We,
what, 1
yeah.
and 62?
Yes, as part
Okay.
of the recommended sentence, in exchange for the defendant agreeing to the special conditions that we asked the court to impose, the state was willing to null pros count 1, count 57, and count 62.
Okay, and then all of that consecutive to the probation, that was going to be what we call backloaded, and what were y'all proposing with regard to that, since it was
The
going to
total-
follow the probated sentence?
The total sentence was 43 years to serve, with the first 5 years in prison commuted to time served, followed by 15 years on probation, followed by 23 years in prison, which would have been served in confinement, except that if defendant had complied with the special conditions of probation imposed as part of this sentence, the backloaded portion of defendant's sentence would have been commuted. However, should defendant had violated any special condition of probation within the first 15 years of his sentence, his probated sentence would have immediately been revoked, and he would have been required to serve the entire remainder of his sentence confined to the Georgia Department of Corrections.
All right, so as long as he had successfully completed his 15 years of probation, the 23 years that was going to follow it was going to be commuted to time served, as long as his probation was successful. Is that right?
Yes, Your Honor.
Okay.
And the special, would the court like for us to?
No, I was really more interested in the length of sentence and what y'all had. I know you didn't reach agreement, but y'all, that's what the last offer had been, with, of course, a bunch of special conditions, which I guess is where the hangup was. I don't know.
Right, defendant did not want to agree to the
Okay.
special conditions.
All right. Is that basically your understanding too, Mr.
Yes, Your Honor.
Steele
It
and
would
Mr.
have been,
Adams?
yes, Your Honor, Mr. Williams would have been released today for 15 years on probation. If he successfully completes that probation, then he would not have to go to custody. If he did not, he'd face probation revocation, as well as 23 years, as the court said, backloaded in the Georgia prison system. But we
Okay.
could not come to terms on all the conditions that the district attorney was insisting upon.
Okay. All right. Thank you. Go ahead, Ms. Love.
Okay. And Mr. Williams, were you aware of that previous offer, as well as all of the requirements that that offer would have entailed?
Yes.
And had you had enough time to discuss that particular offer with your attorneys?
Yes.
All right,
The previous one?
the previous offer.
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge in this indictment? Do you understand that, Mr. Williams?
Yes.
Do you understand that if you enter into a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced?
Yes.
Oh my God.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
I'm not on probation.
Okay, so you're
Yeah,
not on
if you
probation.
were on probation,
Yes, yes, yes.
but if you're not, then it doesn't matter.
Okay. Do you understand that if you are placed on probation of any kind by this court, you cannot violate any criminal laws of any governmental unit or any special conditions of probations without being subject to revocation for the balance of the sentence the court imposes?
Yes, I know. I know.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, and the Department of Corrections or Board of Pardons and Paroles, and that no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that, Mr. Williams?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or if you use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of up to 1 to 15 years in prison?
Yes.
Okay. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty? Do you understand that if you went to trial, you would have the right to that if you continued at trial, rather, you would continue to have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself? Do you understand all of those things?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury. Do you understand that?
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses against you.
Yes.
The right to continued assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the continued trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proven beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial. Do you
Yes.
understand?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Well, Your Honor, may I interject?
You may.
Your Honor, on count 1, which is the racketeering conspiracy count, Mr. Williams is tendering a plea under nolo contendere. As to count 56, which is participation in a criminal street gang activity as being a leader or a supervisor or organizer, Mr. Williams is also tendering a plea to this honorable court as under nolo contendere. The balance of the counts, so he is tendering a guilty plea.
Your Honor,
Yes, ma'am.
would the court like to hear from the state or not?
About the NOLO issues?
Yes.
Sure.
Your Honor, the state asked that the court not accept a nolo plea and require either a guilty plea or a not guilty plea as to these charges.
All right. I'm going to permit a NOLO plea as to counts 1 and 56.
All right. Mr. Williams. As to count 57, participation in criminal street gang activity, how do you plead?
I plead guilty.
As to count 58, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 59, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 60, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 61, possession of a firearm during the commission of a felony, how do you plead?
Guilty.
And as to count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, how do you plead?
No law.
As to count 56, participation in criminal street gang activity under the leadership charge, how do you plead?
No law.
I think you didn't ask about count 62.
As to count, thank you, Your Honor. As to count 62, possession of a machine gun, how do you plead?
Guilty.
Are you pleading guilty to the offenses you have indicated because you are in fact guilty of these charges?
Yes.
All right. Are your guilty pleas and your NOLO pleas freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today's date for a felony charge and 12 months from today's date you don't have a misdemeanor charge? But to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea. Your Honor, also, do you?
You have
my-
30 days from
I was-
today to file a direct appeal from this guilty plea and until the end of this term of court to file a motion seeking to withdraw the guilty plea, which does not mean it would be granted, but that's the time period, okay?
What's a direct appeal?
Well, you can talk to your attorneys more about it, but it would be up to one of the, like the Court of Appeals, I think is where this one would go. Those are just the
And-
time periods.
And Your Honor, the state, in addition to the sentence we are asking that the court to impose,
Okay.
we would also be asking the court to require or to forfeit, have defendant forfeit all of the property that has been seized and that is currently being held, that was found or recovered or taken from his home after it was searched on May 9th.
Do you have any kind of list of what that property is? I mean, I'm not familiar with what was seized.
And Your Honor, we're not
We
not
do,
agreeing.
and that,
Oh, I know, I mean, I assume y'all aren't agreeing to anything.
not
but you
agreeing
would
to that.
We're not.
Present it as a negotiated plea.
we're not. But we do have a list of the
All right.
property
Do you have
items.
it where available right now?
Yes, actually, would the court permit us to send it electronically?
Sure,
Because we
that's fine. And then if that is not imposed as a condition, is it just get litigated as like any forfeiture matter?
Yeah, it's
Yeah,
a
it
ci-
would be litigated
it's a
later
s-
on, yes.
It's a civil separate filing
Okay.
in this court. It's not related to the criminal.
right.
It's related case, but it's unrelated.
Understood.
And we are sending that to Your
All right.
Honor
Thank you.
at this time. And as it relates to the conditions of a conviction under 1615-4, Your Honor, we would ask, or as part of the sentence, defendant would be required to adhere to the requirements, the sentencing requirements of the gang statute, which at least in part require that he not associate with any gang members whatsoever. And I can read the rest of that into the record if the court requires, or I can continue with the factual basis.
All right, and let me ask you, because I know that at least while y'all were negotiating, one of the things that I guess was being negotiated was some exception for, I think, somebody that is contractually obligated on his record label.
Eh.
Is that something that the state would still be in agreement to?
No, Your Honor.
Okay,
What was that about?
all right, go ahead.
All right. Your Honor, as part of the requirements of 1615-4,
Yes.
defendant would, one moment, Your Honor.
Shout out to Keita G.
Under 1615.4, in addition to any other penalty provided by the code section, all sentences imposed under the code section shall require as a special condition of the sentence that the person sentenced shall not knowingly
Slow down
have.
just a tad, because there's a
My
court reporter
apologies.
taking it down. And when we start reading, we read really fast. So go ahead.
This code section shall require as a special condition of the sentence that the person sentenced shall not knowingly have contact of any kind or character with any other member or associate of a criminal street gang, shall not participate in any criminal gang activity, and in cases involving a victim, shall not knowingly have contact of any kind or character with any such victim or any member of any such victim's family or household. So that is, and we've listed in our indictment the victims of the crimes, the overt acts that have been committed, and under the basic conspiracy law, those are the victims that we are naming. Your Honor, as this case has been tried and would continue to be tried until the state completed its case in chief, the evidence has shown that the defendant,
Steele keeps closing his eyes. His eyes are closed.
throughout the time between
Oh, he's looking
2013
down.
to 2022, conspired with both indicted and unindicted co-conspirators to participate in the enterprise known as Young Slime Life, or YSL, through a pattern of racketeering activity. Throughout that time, multiple conspirators, both indicted and unindicted, and including the defendant, have committed overt acts intended to further the enterprise itself. With regard to the defendant, as far back, the evidence has shown, as 2013, the defendant, along with other YSL founding members, Walter Murphy, for one, committed an aggravated assault and armed robbery against Derek Dotson. The court has heard evidence of that presented through Adrian Bean, who was a co-conspirator in that particular act. The armed robbery of an Archillian Bennett back in 2013. As alleged in the indictment, defendant and unindicted and indicted co-conspirators committed acts to further YSL that included drug sales, aggravated assault, and murder. They used and furthered, rather, this conspiracy by using social media posts and music to assert the violent nature of and the dominance of Young Slime Life, which is also known as YSL. The defendant is charged with being a leader of the gang YSL, and evidence has been presented by accomplices and co-founders of YSL, Trontavia Stevens and Walter Murphy, and evidence would have been presented, in the words of the defendant himself, that the defendant, as shown by some of his own social media postings, was the founder, one of the founders of YSL, along with Mr. Stevens and Mr. Murphy. YSL formed, according to the evidence that has come out in this trial, in 2012, 2013, under the former version of the name of the gang called Rock Crew, or Raised on Cleveland. The court has heard evidence of the 2014 and 2015 incidents that have involved conflicts between YSL members and IF gang members, that included someone shooting the window of Mr. Williams' car and armed individuals rushing outside during shootings at Club Crucial, to ensure Mr. Williams' safety, shootings at a place called the Dugout where armed individuals rushed to ensure Mr. Williams' safety, shootings at Mr. Kelvin Watts committed by members of YSL, communication with members of YSL after those incidents, and ultimately the murder of Donovan Thomas at the hands of members of YSL. The evidence has shown and will show that on January 10th of 2015, members of YSL drove a car rented by the defendant, a gray Infiniti, and drove past Mr. Thomas as he stood outside of a barber shop congregating with friends, and unloaded an array of bullets on Mr. Thomas, hitting him, his Chevrolet Tahoe, and 2 other persons in the process. Mr. Thomas died from those bullets. Phone records show that communication was held between Mr. Williams, Mr. Kelvin Treadwell, Mr. Demise McMullen, corroborating accomplice testimony that has been presented in this courtroom regarding what happened, who committed the murder, and what happened to the guns and the vehicles that were used in the murder. After the murder of Donovan Thomas Jr., the members of YSL responsible for the murder and members of YSL who were not responsible for the murder congregated at Mr. Williams' condominium called the Sky House, and they all made plans and later either drove or flew down to Miami. Prior factual acknowledgments by members of YSL include that Mr. Williams gave each of the persons who accompanied him to Miami money to lay low as they left the city following the murder of Mr. Thomas. The evidence has shown the ensuing conflict that occurred after Mr. Thomas was killed. It has shown shootings at Mr. Rashawn Bennett's home, shootings at Mr. Darren Mills' mother's home, and I said Mr. Rashawn Bennett's mother's home. Shootings unrelated to the conflict with members of If Gang, of a Lil Wayne tour bus. That shooting followed the confronting by Atlanta Police Department of members of YSL that drove to the compound where Lil Wayne was making an appearance and who drove there with the intent to disrupt and cause harm and to shoot up Lil Wayne's tour bus. Lil Wayne was another artist with whom Mr. Williams was having conflict, according to the testimony that had been presented. Mr. Williams had come out at that time with a mixtape that carried the name of an album that Mr. Carter was set to release and was not able to because his label would not allow that to happen. That caused a contractual or the threat of a lawsuit. It caused Mr. Williams angst. He posted about it. He said derogatory things about the persons who were threatening him with the lawsuit. And as a result, he had to rename his mixtape to something different than what he initially intended. The person who ultimately was convicted of shooting that tour bus up, Jimmy Winfrey, is a person that I believe that recordings have come in regarding jail phone calls, rather, from Mr. Winfrey and members of YSL regarding communication about getting a lawyer. Following the shootings that occurred in 2015, music, social media postings, and other overt acts were committed by Mr. Williams and other members of YSL, taunting members of groups that they considered opposition to YSL, posting of threats of violence by members of YSL against those people. Specifically, the music, Your Honor, contained lyrics such as the following:
She's reading the lyrics. Come on, lady. I hope it's a banger.
I rep my life for real, for slimes, you know I kill. I shoot at your mammy, need to stand down. I up my stamina, take it to trial, get an appeal, take it to trial. Pay for that casket, that's just if we whack 'em. YSL slimy and shady, watch me whack that bitch, pop 'em like assist, Glock with the assist. It also consisted of a song wherein Mr. Williams sang or rapped the lyrics, hey, this is that slime shit, that YSL shit, killing 12 shit, fuck a jail shit. I'm in the VIP, I got the pistol on my hip, fuck the police. You praying that you live, I'm praying that I hit, this that slime shit. 100 rounds in a Tahoe, I'm prepared to take them down. Got banana clips for all these ends acting monkey. This is that slime shit. This is that mob shit. Fuck the judge, YSL. This that mob life.
Acting monkey. Hold up now.
Defendant Williams released a video on YouTube of a song wherein he states, I shot at his mommy, now he no longer mentions me. Act like you want war and they gonna smoke you like a blunt. Another song, I escaped every one of the licks because I was supposed to be rich. I don't care nothing about a cop. I'm just telling you how it is. I done did the robbing, I done did the jacking, now I'm full rapping. Gave the lawyer close to $2 million, he handles all the killing. We don't speak about shit on wax, it's all my business. We know to kill the biggest cats of all kittens. In another song, I was on Cleveland, stuck like a magnet, bitch ass N-word, pay for that casket, that's just if we whack 'em. And yet another song, Defendant Williams raps, red just like Elmo, but I never fucking giggle, YSL won't fold. Pick his ass off from the balcony, wipe an end's nose. I'm gonna F for the cash, then she getting robbed by Tick, a reference to Trontavious Stevens. All I ever wanted was the money, put your hands in the air if you dare. F and N, put him in a wheelchair. And even later on, Mr. Williams, and I believe that this was in 2019, made a post to YFN Lucci or Rayshawn Bennett. If I ain't like what you do for your mother and kids, I would have been killed you. And in yet another song entitled Anybody, Defendant Williams stated, I never killed anybody, but I got something to do with that body. I got the streets on my back, carry it like I'm moving a body. I told them to shoot 100 rounds like he trying to movie the body. Ready for war like I'm Russia. I get all types of cash. I'm a general.
Shout out to Sally.
As Mr. Williams' prominence in the music industry rose, his ascension within or in leadership in the gang YSL became more apparent as he rapped and talked about the crimes that YSL co-conspirators and members committed and how he got away with robberies. With respect to the Donovan Thomas murder, the court has heard evidence through phone records that within 6 minutes of the shooting of Donovan Thomas Jr., a phone call was made from Demise McMullen's cell phone to defendant Williams' phone. And then immediately after that call, Mr. Williams calls his sister Dora Greer and then calls Kelvin Treadwell. There's then a series of calls between Dora Greer and Treadwell, and then Treadwell calls Demise McMullen or Nard. All of those calls happen within 15 minutes of the 911 call. And as I have stated before, the court has heard accomplice prior inconsistent statements about who committed the murder itself and what happened afterwards. The conflict between YSL and members of IF Gang continued into 2019, wherein Mr. Williams raps the lyrics that I referred to earlier. In May 2019, a YSL member shot multiple times at a vehicle owned by Rayshawn Bennett, a black and red Mercedes-Benz G-Wagon. At the time was being driven by a Milton Howard Jr. It was after that incident, later in August 2019, that defendant Williams posted on his page the language YFN, if I ain't like what you do for your mother and kids, I would have been killed you. The post was then deleted from his account. Through text messages of a co-conspirator, Marquavius Huey, there was communication between Mr. Huey and Mr. Williams, both in January and in September of 2020. On January 19th, 2020, Mr. Williams sent a flyer to Marquavius Huey with the performance location of Rayshawn Bennett or YFN Lucci. And when he sent that, he sent it with the message, "Handle that tonight, SLAT, SLATT. Mr. Huey responded, SLAT, SLATT. On September 2nd, 2020, Mr. Huey sent a flyer to Mr. Williams with another performance location of YFN Lucci. And Mr. Williams responded, SLATTY, that is SLATTY, handle and stay very low. Mr. Huey responded, SLAT, and for show, FASHO. I've been out the way and appreciate you for everything, my brother. Never about money with me. I'm built on loyalty. Mr. Williams responded, SLAT, handle that. I got you. Through text messages and on a separate occasion, Mr. Huey said and conveyed to Mr. Williams that he would sit down for any one of them. And I believe that to be a reference of going to jail. When Mr. Bennett was not killed in 2022, Jaden Myrick sought permission from defendant Williams to stab Mr. Bennett while Mr. Bennett resided with Mr. Myrick at the jail. Mr. Myrick reached out to co-indictee Khalif Adams, who reached out to co-indictee Demikion Garlington to get permission from Mr. Williams. Demikion Garlington was also involved in the back and forth shootings back in 2015. On February 9th, 2022, Rashawn Bennett was stabbed by Jaden Myrick at the Fulton County Jail. And after that stabbing, Mr. Myrick reached out multiple times to Mr. Adams for some type of compensation for the stabbing. Mr. Adams reached out to Mr. Garlington about the payment for the completion. On February the 22nd, 2022, YSL co-conspirator and co-indictee Christian Eppinger called YSL co-conspirator Antonio Sumlin to get permission to finish what Mr. Myrick could not complete, that is the killing of Mr. Bennett. Mr. Eppinger asked for payment for a lawyer. However, these calls were intercepted and Mr. Bennett was relocated. In March 2022, information about the stabbing made the news, and shortly thereafter, a series of violent offenses occurred. On March 11, 2022, YSL associates Christian McMiller and Darius Ford were gunned down. Mr. McMiller is a childhood friend of Mr. Williams. Mr. Ford was also a friend of Mr. Williams. On March 12th, the day after, there was a shootout near the Cleveland Avenue area. A shooting by a YSL associate, Stephen Harris, in YFN territory occurred, and a YFN member was shot in the head. March 11th through March 14th, there were a number of social media posts going back and forth between members of YSL and YFN. One of them was a post by Shannon Stillwells. "We ain't the only ones who ain't gonna be crying, that's going to be crying." After a posting was made by Mr. Watts picturing him, Mr. Shamel Drinks, and Mr. Jasper Walters, on March 14th, 2022, after YSL members spotted Mr. Drinks at a gas station, Mr. Drinks was gunned down as he drove away from the gas station and waited at a red light. Later, Mr. Stillwell, Mr. Nichols, Mr. Garlington, and Mr. Farley were all charged with the murder. That is one of the acts that we are still and would anticipate the court seeing the evidence of during the course of this trial. After grand jury warrants were issued after this indictment for Mr. Williams and 27 other co-conspirators, following searches of phones, wiretaps, and other information that led police to understand the role that Mr. Williams played in the YSL street gang and enterprise. Mr. Williams' home, he was arrested at his home and a search warrant was executed inside his home. While at his home, a sale amounts of illegal narcotics, including those that he is charged with in this indictment, was found. Also found was the machine gun with which the defendant has been charged in this indictment. The gun had a switch. The narcotics included marijuana, codeine, and cocaine. And inside the home were also other guns besides the guns with the switch. The items were seized, and again, Mr. Williams was subsequently arrested, along with other YSL members at Mr. Williams' home.
Organization and Wisconsin.
Your Honor, that is the evidence that I believe has been shown throughout the course of this trial and that the state would continue to show. There are several messages between Mr. Huey and Mr. Williams inside the cell phone, that one of the cell phones that were recovered from Mr. Huey. Besides the
including the class.
messages about tells Mr. Williams he has a new number. Mr. Huey asked Mr. Williams, hey, my brother, I'm fucked up. You ain't got nobody I can pull up on and have something in my pocket. Mr. Williams responds, slat, let me call BEO. Mr. Huey responding,